Okay, well, good afternoon, everyone. I'm Simone Carton. I'm the CEO of the ACT Law Society. I'd like to start today's webinar by acknowledging the Ngunnawal and Ngambri peoples on whose land I'm joining you from today, as well as the traditional custodians of country throughout Australia and their connections to land, sea and community. I pay my respects to their elders past, present and emerging, and also to all Aboriginal and Torres Strait Islander peoples joining us today. Welcome to the introduction to anti-money laundering. Today, we're very fortunate to be joined by Lana Nadge and Jeremy Moller. Lana is a solicitor with diverse experience and has played a pivotal role in the Law Council of Australia's anti-money laundering and counter-terrorism financing policy development. As a facilitator of the Law Council's AML-CTF working group, of which I'm privileged to be a part of, Lana is driving the Law Council's engagement in this space, including overseeing initiatives like commissioning an analysis of vulnerabilities in the Australian legal sector by New Zealand law firm Russ & Associates. As principal of Nadge Advisory, Lana's practice spans employment law, planning and environmental law, animal law and policy work in New South Wales. Jeremy Moller is a Sydney-based risk advisory lawyer with over 15 years' experience across Australia, the UK and New Zealand, specialising in anti-money laundering, international sanctions and export controls. Engaging regulators like AUSTRAC, he leads, implements and reviews financial crime programs, advises on regulatory litigation and participates in royal commissions. Jeremy's holistic approach merges legal compliance and operational risk management, ensuring client satisfaction as well as regulatory adherence. As a member of the AML-CTF working group with the Law Council of Australia, he stays at the forefront of regulatory developments, including the anticipated Tranche 2 AML-CTF regulation, which will affect real estate agents, lawyers and accountants. So thank you both for joining us today. It might be best if we start off with the basics. So let's start with the question, what is anti-money laundering and counter-terrorism financing?
And this is where we decide who's going to answer that question.
Please go ahead, Lana. Take the lead.
Okay. Anti-money laundering and counter-terrorism financing. Well, I guess it also begs the question, what is money laundering and what is terrorism financing when we're talking about beginning with the negative of anti and counter. But to answer the question specifically head on, it's a term of art, really. People will know that the phrase anti-money laundering, counter-terrorism financing appears in a major federal act. So the 2006 Act, which is the primary legislation that regulates entities, including financial institutions and casinos and others. We'll come to that later. But that's sort of anti-money laundering and counter-terrorism financing is linked to that statutory regime. People will know that legal practitioners, with very, very limited exceptions, are not covered by that Act. And that's something that, again, we'll come to in a bit more detail later. But the term of art, counter-terrorism financing, anti-money laundering, is really about a global initiative that Australia is a part of, which is designed to deter and prevent and detect money laundering and terrorism financing. And there's much more we could say about that. Jeremy, do you want to add to that picture?
Happy to. So money laundering is often the movements of the proceeds of crime, and typically that's where there's a predicate offence. So offence has already happened, and then it's the subsequent movement of that proceeds of crime and becomes money laundering. So actually a very broad term, and it's often one of the challenges when dealing with the subject matter is how broad it can be, and it often goes to the level of knowledge about that predicate offence and the movements of those proceeds of crime.
So I'll go, Lana.
Sorry, Simone. I'd just add that when we're talking about anti-money laundering and counter-terrorism financing, we're really particularly in the context of legal practitioners, but also in the context of the banks, casinos and other currently regulated entities. We're talking about ensuring that those entities, legal practices, banks and others are not unwittingly drawn into complicity with money laundering and terrorism financing. And that's the point that Jeremy just made, in other words, just now. So, so the degree of knowledge matters, and sometimes people, when approaching this area for the first time, sort of scratch their heads and say, but you know, there's already the criminal law that deals with you know, my involvement in fraud or money laundering, terrorism financing, other serious crimes. So why are we talking about this? Well, it's actually it isn't. The clear-cut answer that's always often given is slightly misleading, because in fact knowledge, as we know as practitioners, it always falls across a spectrum, and it's not really necessarily black and white as to whether you know nothing and right through to whether you ought to have known on reasonable grounds because of various indicators that you may or may not have noticed, but perhaps you should have noticed, right through to someone who knows what they're doing and willfully breaches the law, which is where the criminal law is the mighty tool that the state has. So when we talk about anti-money laundering and counter-terrorism financing, really we're positioning ourselves on the other side of the spectrum to the criminal law, if you like, which is where the unwitting lawyer might be drawn in, or the bank that isn't paying as much attention as it should have might find itself in trouble.
When we're talking about AML and CTF, you often hear about the Financial Action Taskforce. Could you tell us a bit about what that's all about?
Okay, then there's a lag again. Jeremy, you'll just have to jump in. So the Financial Action Taskforce was formed as a task force. It's now a permanent institution in 1989 against the backdrop of the war against drugs, which had been on foot for a number of decades by then. But if people whose memories are long enough will recall that in the States, certainly in the Reagan era, that war on drugs was huge. And in fact, the United States was the first jurisdiction to criminalize money laundering. And at a meeting of the G7 in Paris, the task force was established, and it now has offices with the OECD in Paris. And I guess what you need to know is that it's often been called the most powerful body that no one's ever heard of. The FATF does wield a great deal of power. It's what you'd call soft power, because they don't enforce hard black letter law, but they do have a set of what are known as the 40 recommendations, so international standards that were initially issued in 1990, just after their formation, but were revised on a number of occasions, and most recently in 2001, when legal practitioners or legal professionals, the term being broader because of the universality of the FATF's remit, were brought into what the FATF urges countries to regulate in relation to. So soft law, it's not binding, but they have international standards that include encouraging countries to ensure that legal practitioners are subject to due diligence, record keeping, reporting and other obligations as part of their policy in this area.
That's absolutely right, Lana. And really what they do is they review through what they call a mutual evaluation, each country's standards and how they're actually complying against that. So whether you can actually be non-compliant given your laws don't meet certain standards, and one of those being the regulation of lawyers, accountants and real estate professionals. So that mutual evaluation typically happens every 5 or so years. The next one for Australia is meant to happen in 2026. So part of the reason that we have this conversation today.
And in terms of, Lana talked about legal professionals and you just mentioned lawyers with Tranche 2. So who exactly is going to be subject to money laundering and terrorism financing obligations then?
Really good question. I think that's, part of consultation that's happening that commenced from the Attorney General's Department in April last year. We should expect a consultation paper soon, the second consultation paper. But the plan at the moment is to regulate kind of broadly 4 services for lawyers. So conveyancing, M&A transactions where a trust account is used in managing the assets of a client broadly.
So, and if I can just add to that, you could ask, well, why those 4 areas? And I think that's a matter of going a step back again and thinking about, well, what is money laundering and terrorism financing? What does it look like? So what are the risks? And you come out the other end after a whole lot of many decades now, actually, of the development of methodologies based on intelligence and countries reporting into working groups of the Financial Action Taskforce and those sorts of deliberations. And you come out with a set of ideas of how money laundering works and terrorism financing, and how those, obviously awful, nefarious processes might present to a professional like a real estate agent or an accountant or a legal practitioner when a client or prospective client comes to see them. So I guess that's sort of the purpose of the ACT Law Society putting on a seminar like this, to see what's around the corner in terms of what regulation might be coming to add to our existing obligations, but also what is money laundering and what is terrorism financing and what does it look like? So I think maybe we can talk a little bit about that.
And essentially, Lana, it's directed to the highest risk areas, right? That's why you have these potential designated services. It's not to add extra burden unnecessarily, but actually why you focus on these areas, because they are the ones which are most susceptible. As you can see, mainly those ones that I listed, those 4 being transactional in nature.
Right, exactly. And sorry, Simone.
I was just going to say, do we know if any areas in particular are going to be excluded? Have we got a bit of an insight into that at this point in terms of the different, we've got a variety of different lawyers in our audience today.
And quite a unique audience, I think, and really pertinent for this conversation. I'll just start with a couple of the ones, and of course, nothing is predetermined yet, and of course, part of the consultation. But litigation lawyers, where you're acting in disputes, that's not seen to be something which would be designated. So that's a large proportion of the legal profession. Of course, issues around access to justice and things like that. Very hard to do your customer due diligence. I say sometimes you'll be seeing the client maybe for the first time in court, something of that nature. So litigation and that criminal work not being captured. And of course, that extends to the bar in that context. I think also for this audience, it's mainly directed towards lawyers in private practice. So whether you're in-house or in a government entity, you will not necessarily have those same obligations. And again, it goes back to that transactional nature. The one thing I would say, though, is the principles are still helpful. We've got to be looking at where there is risk, where there's the potential of proceeds of crime, money laundering, the breach of law. So I would say, while there may not be a legal obligation down the track of particular types of lawyers, we know through, doing due diligence on counterparties, things like foreign interference, it's always important to be live to these types of issues.
So let's talk about risk then. What are the risk factors for money laundering, terrorism financing?
I guess the first thing is to understand sort of the process by which it works. And I think the experts agree, and forgive me for those online, and Jeremy and Simone, who have heard this probably many times, but there are 3 stages to money laundering. There is the placement of money, there is the layering of money, and then integration. And so the placement, they're pretty simple kind of concepts, I guess, but the placement is where illicit funds are entering the system. So that could be through small amounts of money, say under the $10,000 reporting threshold to AUSTRAC, so that it's not flagged by a financial institution, entering through an ATM or however it might be. And so that's just an example, but placement. The layering is the idea that really comes to the root of what money laundering is about, which is disguise. It's about distancing that money from the illicit origins, and to just disguise it, possibly by mixing it with other money. So if you have a cash intensive business, for example, that's being used to pass money through it, there might be money that is clean money and illicit money that is being mingled there. And you can think of other sort of methods that arise from this way of thinking about how it works, like the idea of false invoices being issued, for example, so that it's not clear, even though it's a legitimate business, it might have been taken control of, at least partly, or infiltrated by a criminal entity and misused for those purposes. So that second stage is the layering, and you then have integration. So that's when the money is, say, for example, used to purchase a property. It's come from, say, God forbid, someone's trust account, or another source that appears to be legitimate, and the source of funds behind that is actually an illicit source of funds. So your question, Simone, was what are the risks? And there are risks all through those three stages. Jeremy?
I was going to say, it comes back to the thing of follow the money, doesn't it?
Yeah.
I think we've all sort of heard that, and it's what you said, that source of funds, that source of wealth. Other things to consider: high cash, business, a lot of intensity there, offshore jurisdictions as an example, cryptocurrency, the movement of funds very quickly is a level of urgency, and the movement through different jurisdictions, through shell companies, things like that. These will all be kind of somewhat apparent to us, but I think it's sometimes actually then trying to identify it in the real world, and it can sometimes be a bit more complicated than we realise, and it could be a multiple array of those methods used at once.
Could you maybe take us through a bit about what the vulnerabilities analysis was in that risk approach as well, that the Law Council undertook?
Yeah, sure. So the Law Council was last year in the context of the Attorney General's consultation that's on foot, but also in the context of a global movement to look at really reinforcing the profession's defences against complicity, unwitting complicity in money laundering and terrorism financing. Just made a decision to commission an independent expert to undertake an analysis of the potential vulnerabilities in the national profession in Australia. That was partly also because the Law Council's of the view that good policy is evidence-based, and there's a lot of talk about risk, but there are also times change. We know that these methods that we've been talking about in something abstract terms also change, and that's because criminals' methods evolve, and the world turns. Cryptocurrency is a new phenomenon, of course, so that's just one obvious example. But also real estate is another interesting example because it's often seen to be high risk. We know that, the idea of buying a luxury apartment or somewhere abroad, if you're a criminal, to park your funds is sort of a bit of a cliche. But in fact, when the Financial Action Taskforce, which, as we'll recall, was formed many decades ago now, identified real estate as a risk, it was at a time where cash was really what was front of mind. And of course, now we have a digitised system of transfers, wire transfers across the world. And also in jurisdictions like Australia, nowadays real estate transactions are undertaken almost wholly electronically. So that's not the case in every jurisdiction in Australia, but it certainly is here and in many of the major jurisdictions. And the two who aren't using electronic conveyancing now are steadily moving towards doing so. So the question is, well, what is the risk today, here and now, affecting Australian lawyers? And the Law Council commissioned a New Zealand expert AML and tax law firm to undertake this analysis. So there are a number of findings that we can talk about, but essentially it was a process that was, so it wasn't the Law Council's process. It was a methodology that was designed by by Russ and Associates, and they undertook, I think, in excess of 90 interviews across the nation, and looked at the risk factors and the topologies, the methods that FATF and other experts identify as being the methods used, and looked at the existing controls that are typical law practice, but in fact there's no really such thing, as we know. So many different kinds of law practices have in place, and came out with a report which is publicly available, linked to on the Law Council's website, which analysed the vulnerabilities. And there's a lot of detail, but in effect, I think you could boil it down to the top one being that that we don't always, and I'm generalising here just for the purpose of this conversation, people should really look at the detail. And can I say that very, very large law firms who are already interacting internationally and are often de facto, and even more than de facto, but adopting the standards that are at the European level of the anti-money laundering, counter-terrorism financing regimes. You could probably put them in their own category for the purposes of this discussion, but for the balance, we don't always know whether the client in front of us is potentially acting for an intermediary, or in fact is the beneficial owner of the entity who they are representing. So a vulnerability, in other words, is that we're not necessarily always checking that the person or entity is not a sanctioned entity under the sanctions regimes, or is and we don't necessarily know fully whether they entirely control it, or whether they might be potentially a politically exposed person. And that's another term of art in this area, which is essentially someone who has occupies a prominent function in a jurisdiction where they might be susceptible to bribery, and so for that reason there might be some proceeds of crime that might infect the transaction, or in fact be at the root of the instructions that you're being asked to undertake. So client due diligence, and again I'm painting in very broad strokes here, is an area where some additional robustness could be added in some places. The second vulnerability is that there is a reasonably low level of awareness of the risk of complicity in money laundering and terrorism financing by and large, and that probably isn't so much of a surprise, because it hasn't been something that we've talked about in the granular detail as a profession very much, and are starting to do a bit more. And I'd say there is the other important finding, I think, from the analysis was that of the risk areas, and the Financial Action Taskforce has enumerated 11 of them that are relevant to legal professionals, many of those activities are simply not undertaken by and large by legal practitioners in Australia. So, for example, arranging for contributions to be brought in to establish a company is not something that lawyers here really do. We don't necessarily manage client funds in the way that others in other jurisdictions might do, and so quite a number of those areas are just of low or negligible risk.
And I think one thing I would add, Lana, is just that real estate accountants and lawyers are seen as gatekeeper professions, aren't they?
Yeah, absolutely. That's a really important term to unpack, I think.
And just a question from me, just to provide the context. Why did we get a New Zealand lawyer to do that assessment?
Well, because we like your accent, Jeremy, and we liked Neil's, but no, well, the New Zealand lawyers are regulated under a regime that is not dissimilar from our Anti-Money Laundering and Counter-Terrorism Financing Act. But so the obligations are stringent obligations and reasonably prescriptive. And there's a whole conversation we can have about the merits of that. But also in New Zealand, they were in the invidious position of having been, they being legal practitioners, of having been rushed into accepting these obligations. The consultation process, some would say should have been double the length of the time that it in fact was. And what we hear is that a couple of things happened. Some legal practices basically de-risked, so exited those areas that were regulated because they didn't want to bear the cost of what they perceived to be onerous regulation. And another consequence, which we would very much, we're working hard to avoid, is that there have been a whole series of ministerial exemptions that have had to have been obtained, because when you rush through legislation, you can often take a blanket approach and capture areas where if it's meant to be risk-based, there's demonstrably no risk. And so instead of having that baked into the legislation through a good consultation process, in fact, they've had to go post hoc and solve it that way. So those learnings meant that, and that experience meant that the New Zealand profession were in a really good position to have insights into what risks were, and also how the regime works and where it works well and where it works and where it doesn't. And although that wasn't absolutely central to the instructions, those insights meant that we got a really good outcome, a very interesting, a textured report that picks up on some of the nuances that I think can inform the reform process with the Attorney General's Department going forward.
It means we can be more proactive than reactive. And it was the Panama Papers there that New Zealand got caught up in because of trusts and things of that nature. So you often don't want to wait for a big issue to then react and, as you say, rush legislation through, which I'm sure we all can be aware of and really conscious of. So.
And it's a really important point how that through the vulnerabilities analysis and leveraging that experience from New Zealand, highlighting that some of the FATF risk areas aren't applicable for the Australian profession. The other part that's sort of something to consider in terms of the Australian legal profession is, where do our existing professional conduct rules that we've got frameworks in place already, how do they fit in with what's being proposed? Do they cover money laundering and terrorism financing?
Look, I think they do. And I think that, as we know, the Legal Profession Solicitors Conduct Rules 2015 here in the ACT are legally binding under the Legal Profession Act. These are rules that place the legal practitioner's responsibility as an officer of the court, so the duty to the administration of justice, as a paramount duty. And the administration of justice has, as a corollary of that, as the fact that we are officers of the court, the fact that we have to maintain the highest integrity at all times, and we cannot act in any way that would bring the profession into disrepute. And so what that means, that core idea that underpins the rules, is that we need to know that we are acting lawfully at all times. And the client due diligence responsibilities that are, best practice and flow from that help us to maintain that integrity. The other rule under those conduct rules that's of significance is the rule that ensures that we act competently and diligently. And if we don't know who our client is, then we're not able to competently act for them. And I mean that in the broadest way possible. There's the rule, I think it's rule 9, it's rule 8, I always get that wrong, is to follow our clients proper and lawful instructions. And the obverse of that is that we must only follow proper and lawful instructions. So we are able to terminate a retainer or to decline to act on just cause. And if we believe that we're going to be complicit in money laundering or terrorism financing, that's a really good reason to invoke that rule. So yes, we do have existing obligations. That's just a broad brush under the rules.
And of course, trust accounting, right, Lana, in terms of the movement of those funds and the due diligence that's already done, but also the monitoring that would not only go on by the bank, but also the practitioner in terms of managing that trust account.
What about the, oh, go,
sorry,
Lana. Yeah.
No, just on trust accounts, I think it might be just when we were talking about risk. I know that there's an ongoing discussion about trust accounts. So managing client funds is a risk area in the FATF regime, and a solicitor's trust account is seen by the FATF being the Financial Action Taskforce, as being a very attractive to criminals. And this is a point of some contention because we have rules that ensure that we cannot use our trust accounts except in certain ways, as we know. And there are, and the record keeping around that and the notifications where there are irregularities are really, really strongly enforced by our legal regulators. But I just wanted to tell a little story about Donald Gurney, the Canadian lawyer who allowed 24 million Canadian dollars to pass through his trust account and was disciplined by the British Columbia Authority. Their one methodology is that the provenance of the funds, if it comes through a trust account, it has two functions. One is that it looks legitimate at the other end, and the other is that the next person who's dealing with it, which is related, may ask fewer questions because it's come through the trust account. So in a way, this doesn't necessarily, in my mind, I'm speaking personally here, call for further regulation or obligations, but it does call for an understanding by us that our trust accounts are attractive potentially to criminals, and that those rules that Jeremy was just talking about are important not only to protect consumers from bad lawyers, which is sort of the initial kind of impetus for having monies that aren't mixed and that are regulated very carefully, but they also protect us from bad players. And in order to understand that, you need to understand that what your trust account can look like from the outside. So if someone says, I'd like to buy something and can I just park it? Someone needs proof of funds. Can I just park it in your trust account? And I mean, we all know that no, because there are no legal services that are being provided. Absolutely not. And that person might not be a person who's engaging in money laundering. They might genuinely be not understanding how a trust account works. But all of those fundamentals of legal practice really come into the fore when we're faced with situations like that. So I just wanted to, I sort of didn't tell the story of Donald Gurney, but he's not practicing law anymore and defended himself in British Columbia against the charges of money laundering. But there are, your trust account is potentially a magnet.
And we talked about conduct rules, and we've just talked about the Canadian example of sanctions being imposed, and we know that there's sanctions in the current regime as it applies to banks and others. What's the interaction with the criminal law here? Aren't there already provisions that cover this, or how does that work?
I'm happy to start on that. The main sort of criminal law focuses on whether conduct is intentional, reckless, or negligent as to the proceeds of crime. And again, that is quite broad. There is both federal and state-based laws around this. I think what is helpful about an anti-money laundering regime, but also the steps that you can take, is it helps prevent that intentional, reckless, or negligent conduct. So I think that's one of the things to be really cognizant of. Of course, it would always be fact-based for it to be a breach of the criminal law, but I think it is what Lana referred to earlier, often the unwitting example of a lawyer being drawn into this. So whether they have actually breached the criminal law, but even just been, facilitating that unknowingly, and that can have both reputational damage, but also, yes, an impact on their practice if there's any investigation. And we haven't seen too many prosecutions in Australia, though there have been a handful with respect to those professions. But I think it is worth distinguishing between what is that sort of money laundering and that criminal conduct versus anti-money laundering, which is much more preventative. But I think in imposing a regime, if it does come in, it at least provides a few defences to that. Also, in reporting to AUSTRAC, and we haven't spoken much about that as of yet, but one of the advantages, if you are regulated in this regime and you report to AUSTRAC, that is a defence. So a number of practitioners would be aware they've been put in difficult situations in the past. You're not often going to have full knowledge of that. Is it a situation where you decline to act? You try and provide advice and say, don't take this course of action. It could be a breach of the law to your client. But I think it's already a situation we are potentially involved in, particularly when dealing in transactions. And Lana referred to before, you may not know the beneficial ownership, may not know the ultimate purpose of where the funds are going, whether that's occurring through offshore jurisdictions. So that regime around anti-money laundering can therefore be directed towards preventing some of those criminal law issues. The approach I've always taken is said it's often a gut test about what you sense. Don't practice in the areas that you're not comfortable. Make sure that you understand the nature of your client, their instructions. If you're feeling nervous or there is a concern, that's where you can escalate things and seek the advice that you need. But it is really important that you don't get into that territory of putting yourself in a position where you could be breaching the criminal law.
And I think just to add to that, in order to, as you've just said, Jeremy, that in order to prevent yourself from being in that situation, there's lots of work upfront that you can do in terms of thinking about who your client is and what questions that you might ask them. And, there's been in developing the policies around this, we've had lots of interesting conversations. And one of the observations that comes up from time to time is, well, lawyers don't feel comfortable about asking, where does your money come from and what's your source of wealth? But I mean, when you go to a hotel, you get asked quite a few questions, more than you used to when you have to check in. And I think the world is changing. Cybercrime and all of our policies around cybersecurity have meant that we have had to view the outside world with a degree of suspicion that we don't like to view it with. But we've had to, in order to protect our clients' information as well as our own reputations. And the anti-money laundering, counter-terrorism financing space has some similarities to cyber in that respect, because actually we do have to protect ourselves as well as our other clients, and avoid criminal responsibility. We might have to ask more questions than we used to. So there was a lawyer. No, go on, Jeremy. Sorry.
I was just going to add to that, and particularly for this audience, probity checks which are done, background checks. This is not necessarily new to us. It's just a different context.
Yeah,
so I think
conflict checks, exactly. Our opening the file, our protocols there, which are also enshrined in rules.
That's right, and we referred to it before, you've got to do training for CLE and CPD obligations, but also having a practicing certificate. So there's a lot we're already doing. I think it's often just emphasising that and making that clear. But that's right, in this sphere, as a society, as a community, we're doing more in terms of the space to assess and verify that risk, whether there's a legal obligation to do so. We don't have that at the moment in terms of anti-money laundering, but there are a lot of things that are associated which are close to that we do already do.
So there seems to be an emphasis on knowing your client and the conflict checks and those sort of things. Do you have any other top tips for practitioners in terms of preparing for what we're anticipating is coming? We've talked about that we're not entirely sure when the next consultation paper is coming out. We've been waiting with bated breath, but we know this is coming. Are there some things that people should be doing now? Obviously, as a society, we're going to be pulling information together to help our members get ready, and we'll be leveraging the work through the Law Council that you are both participating in for that. But have you got particular top tips in mind for our practitioners?
Yeah, we're doing the first one, and I think this group has got the gold star already for attending today. So training. Another one is really just actually understanding the risk based on your practice. So, what type of services do you provide? Who do you provide them to? Where are your clients based? And I'm not saying that has to be an in-depth exercise at the moment, but actually just understanding your practice and whether it may be captured by some of the regulated activities that we said before. Looking out for the guidance material. A lot of this is actually a change management process if it comes in. So I think one of those things is there are many entities that do this at the moment, which are already regulated in Australia, so that provides some guidance, but also the approach that international jurisdictions have taken for lawyers. So I think we can take some comfort in that. But I would say assessing your business, doing training, and what I always say to clients is, when was the best time to start? Well, yesterday. So I wouldn't necessarily wait for the last moment if regulation does come in, but appreciating, we may have a time in which to comply, but often it means the consultants and people that can assist, the support from the society, there is a time burden on that. So starting early is one of the best things to do.
Lana, did you have anything to add?
There's material online. You alluded to the fact that the Law Council is working on national guidance, which will be at a high level, but will include some of the red flags to look out for. And I think that there are two aspects of this. One is strengthening your existing processes, so your client intake, thinking about in that context, for example, do I ask for client identity and verification for particular reasons, say? So if you do conveyancing and you have, for example, you have international clients quite often or often enough, you might consider looking at asking for the information that might be going out for a Foreign Investment Review Board application later down the track, bringing that request for information up front. Instead, that can only help you and to know what's coming. And so strengthening your own systems and thinking about that, but also looking at developing your awareness of what those red flags might be based on the sorts of risks and methods that we were talking about earlier. So the guidance that's in the pipeline will have examples of those. But when I said there's material online, what I'm referring to, we'll end up having some links to these things soon. But for those people who are so keen after this seminar to get out online and have a look, that's not a waste of time. So the Financial Action Taskforce has a document on the legal professionals' vulnerabilities, and there is a guidance for a risk-based approach. Now, those linked their 40 recommendations. None of it's binding at all, but it's actually really interesting material and very helpful, I think. It's also voluminous, so it's, I caution you about that. But people who want to go and get to know through case studies and examples a bit more about this area, you could do that for sure.
And we'll be pulling all that information together into a section of our website that we link through to the Law Council's information and to the FATF information that Lana's mentioned as well, to help you all get on top of what's coming and hopefully get a little bit ahead. And there'll be more to come, I'm sure, throughout the year as we get more of an idea when we see the next consultation paper. There might be some people who are thinking they've got some questions at the moment. You should be able to use the chat function to put questions through if you'd like to ask Lana and Jeremy specific questions that you might have around this space. We've already talked about some of the interaction with conduct rules and criminal law. Can you talk us through maybe some of the penalties that we already know are in the current regime and what we might be expecting for lawyers?
personal hope is that penalties are a long way off. One of the things that we have heard through the consultation and my dealings with Austrac otherwise is they do want to take a collaborative approach with industry. I think what often gets the headlines, and we're quite cognizant of it, is those large fines. And there is ongoing enforcement action. But I think what I would make a distinction is that as some of the largest reporting entities, they've been in this regime for close to 20 years. And I think it's looking at that scale. Some of these entities have hundreds of people who work in relation to anti-money laundering and other compliance. Re the legal profession, I think if we do become regulated, it should be a collaborative approach. Austrac has an interesting setup compared to other countries, as it is both the financial intelligence unit, so receives the intelligence and the reports, but is also the regulator. And some other jurisdictions, that role is split. So for example, in New Zealand, it's New Zealand Police, who is the financial intelligence unit, and then you have 3 supervisors. So I think one thing to keep in mind across that process is it's about early engagement and level of compliance. There can be fines down the track, but I would hope that's some way off. Jurisdictions like the UK, there are often fines coming out for lawyers. It can be for smaller infractions, but they've had a regime since about 2003. So I think they've really gone on that journey. But yeah, my hope is the emphasis is on that compliance as opposed to that enforcement. And that's something, Lana and I and the rest of the team at the Law Council that have been engaging on the consultation are emphasising that there needs to be a balance which is struck.
And a related question would be around, from what you've seen internationally, would you expect our practitioners to be audited as part of this regime?
There's an existing point under the Act which requires an independent review periodically. That can be internal or external. Periodically is thought by the market to mean every 2 to 3 years. The idea is that somebody comes in, reviews what you do, and effectively gives recommendations as to what best practices and how you can improve. I think, as I referred to with resource earlier, this is one thing to keep in mind. There are 17,000 reporting entities, so regulated entities in Australia at the moment. That number would greatly increase with lawyers, accountants and real estate. So I think that's one of the points to keep in mind, that expertise that we have at the moment, but the need to grow that if this regulation does come in. But that's right, there will be that external support in terms of independent reviews. There is a cost element to it. And just actually, can be based on the nature and size of the practice. So again, we know there are the largest firms like my own that operate globally and have good staff that undertake a lot of this work. Totally appreciate for smaller firms, this can be difficult. I think the statistic, Lana, is that 93% of firms across Australia are sole practitioner, or maybe it was 89% sole practitioner, 93% are 4 partners or less. So when we compare this to other industries, it's not just small business, it's what we term micro business. So the impact on the profession, we're very cognizant and mindful as we go through the consultation.
Yeah, and that's I was just going to say something we're thinking about with the small to medium businesses, some of whom are represented here today. Thanks, Lana.
Yeah, no, I was just going to say that these, if whatever audits there are and regulatory oversight of the specific engagement with the specific risk of money laundering and terrorism financing, your best protection is going to be your level of awareness of risk. Because that's going to always infuse the systems that you have in place in your practice, and it's going to inform your answers to auditors and to regulators, and it's a genuinely helpful protection to have in place for you anyway. So I think that education process and awareness is really important. So for all of those people who came today, that's brilliant. In cybersecurity, as we know, everyone in the practice is vulnerable. So like if you pick up I don't mean to hype up the risk here. But all I mean is that it's not just the principal of a practice who is the one, they have ultimate responsibility, but then not the only person who needs to know about what money laundering looks like and how it can present and terrorism financing. It's actually, it's the person who does the client intake, if that's someone else. It's all staff of the practice, really. And so in the regulated form of, as in regulated for the specific risk, in those jurisdictions where that regulation takes that form, there's often a compliance officer who is nominated to look at how the systems work and is the go-to person to go and talk to about any anti-money laundering and terrorism financing as well. So it's just kind of that idea of like, how do you build in that that knowledge and that awareness in a collaborative environment into your practice. And I think that if you start thinking about that, then you're more than halfway there.
I haven't seen any questions come in, but there's a couple of specific things that people might have heard about that they might be interested in just as we come towards the end of this session. There's been discussions about a reporting requirement for suspicious matters. Do you have any inkling as to whether that's going to come in, or whether there's been further consideration around legal professional privilege and confidentiality and how you manage that with your clients in the context of that sort of reporting requirement?
Lana, do you want to start?
Yes.
This is the difficult one. So
yeah. Look, it is a really tricky. So under, I think it's section 41 of the current AML-CTF Act, there is a provision that reporting entities, and that's what you are if you're covered by the Act, reporting entities must report a suspicion to AUSTRAC in a particular form if they form a suspicion on reasonable grounds that that there is, and then XYZ, a whole range of matters that can come to one's attention, including the dealings with the proceeds of crime or an instrument of crime, so terrorism financing or money laundering. But it also, that list XYZ does include other offences, and so as a potentially regulated entity, because that's what this Attorney General's consultation is about, legal practitioners and the profession nationally is concerned that we are a little different, to say the least, to other current reporting entities. So our practices are made up of confidential information that we hold for our clients. The information that we would provide to a financial intelligence unit, so that's AUSTRAC, about a suspicious matter in relation to a criminal offence, or in fact, something that may assist with the investigation of a criminal offence is in fact one of the thresholds in that list as well. We think that while that may or may not be appropriate for other regulated entities, we have serious questions about the appropriateness of that breadth for our particular context. And we are officers of the court, and as well as a potentially regulated entity. So our duties are quite unique, and it's important to us that we have an open and engaged dialogue with the government about how, if there is to be a reporting requirement, how that is finally calibrated to the specifics of legal practice in Australia. And that means not the least that confidentiality is fully protected and that legal professional privilege is not abrogated. I'd just say before I hand over to Jeremy on that point, that what we have in our, that it gives us comfort is the fact that at the level of the global level, Financial Action Taskforce itself, when making its recommendations about what anti-money laundering rules should look like, say that they should never impinge upon legal professional privilege. They call it professional secrecy in terms of being more across the board in their application. So, that's our starting point, and the government accepts that starting point. But we're waiting for more news in the next consultation paper as to what plans are in that regard.
Yeah, just endorse that position, Lana. The one thing I would say, and having practiced in this in terms of the global operations of law firms and where there is a reporting obligation overseas, is just where it's not always your client, the one that would be disadvantaged. It could, for example, be a counterparty. So I think that goes into this type of assessment. And as you rightly say, the level of confidential information that you may hold or privileged information, one of the things that can actually be before it's a client entity, it may be a client who's coming to you and giving you fake documentation. So whether there's a reporting obligation there, but totally appreciate what you're saying and endorse it in terms of the need to balance those. And I think that's the interesting part of practicing in this area. It's always subject to the specific circumstances, and they are many and varied. So, it always has to be looked at in that context.
There are different regimes in different jurisdictions as to how those suspicious transaction or suspicious matter reports operate. In the United Kingdom, when a practitioner or a regulated entity lodges a report, they can lodge it at the same time as they ask for approval to continue with the matter, the transaction. That's called a DAML, they call it DAML, I think it is. It's a defence. At the same time as lodging a report, they're seeking a defence for if they continue, they're protected from liability against having been complicit in money laundering or dealing with the proceeds of crime. So that's one model. And there's a different model in New Zealand which doesn't seek that approval. And so there's all sorts of regulatory reasons for that, which we don't need to go into now. But this is a moving area, and we're exploring the pros and cons of all of those.
So in 1 minute each, is there anything else that you would want to add just to wrap up the discussion?
I'd just say stay engaged, and thanks very much for people's interest in the question. So watch this space. There's going to be more information coming out, and I think it's only going to become more relevant to your practices as we continue.
Yeah, the only thing I would add is just speak to those around you and those that you work with. I think it's about getting the message out there so it's understood what is potentially coming and just how you can respond to that.
Okay, well, I'd like to thank Lana and Jeremy. Again, I haven't seen any questions come through. If anyone does have any questions, look, feel free to send it through to our events email, and we can certainly come back with more information as we start to collate the information for members as well. Thank you to everyone for joining. You did get a nice tick from Lana and Jeremy for taking the step of actually getting on top of the issues that are coming by attending this webinar. So thank you for doing that. Please do complete the feedback forms, which will be sent out to you as well. And once again, thank you, Lana and Jeremy, for your time today. It's been great having you.
Thanks, Simone. Thanks so much for the invitation. Thanks, Jeremy.
Thanks, Simone. Thanks, Lana.
Thanks, everyone.